Hi, this is Erica Eckley, and we're going to focus a little bit this week on some of the litigation surrounding the Affordable Care Act. The Affordable Care Act was signed into law about 5 years ago, and since its inception has been subject to a number of lawsuits. Today we're just going to focus on two of the lawsuits dealing with the Affordable Care Act and its provisions, the Sebelius case and the King versus Burwell case. There have been other cases. You've probably heard of the Hobby Lobby case, in which the closely held company, the Hobby Lobby company, its owners have religious beliefs that do not conform with the ACA's requirement to provide birth control to women under the health insurance. And so that was litigated to the Supreme Court. The Supreme Court did hold that the closely held company was not required to specifically provide the birth control benefits, so they would have to, the federal government would have to make some accommodations so that the women would be able to receive their health benefits, but the company itself would not have to violate its members' religious principles. But I'm going to focus today on the first case, the NFIB, the National Federation of Business versus Sebelius case, that was originally decided upholding the Affordable Care Act in part and finding part of it was unconstitutional. With this case, the NFIB, 25 states through their attorney generals or governors, and a number of individuals and businesses sued Sebelius, who is the Secretary of the Health and Human Services, the agency that's required to move forward with the ACA to write the rules and regulations and to enforce most of the health insurance aspects. The IRS is also charged with enforcement of the penalties, as we'll talk about later. But Sebelius is the Secretary of Health and Human Services, so she was, they did sue her to argue about the constitutionality of this. And this case focused on two provisions of the Affordable Care Act. The individual mandate. As you're aware, the Affordable Care Act does mandate that individuals have to either have insurance through their employer, or they do have to go purchase insurance through the marketplace, or they have to receive insurance through Medicaid, either traditional Medicaid, Medicare, or the expansion of Medicaid. And then the other issue was the constitutionality of the Medicaid expansion. In the Affordable Care Act, it was anticipated that every state would expand Medicaid to include all individuals who were low income. The traditional Medicaid covers only individuals who have health issues and and left out a lot of individuals who, simply by reason of their lack of resources, were not able to acquire health insurance. But they did not have any specific health issues that would make them eligible for the traditional Medicaid. So in this, the Medicaid expansion, it was anticipated that every state, all 50 states, would expand Medicaid, and the federal government would. So these are the two issues that were reviewed in this case by the Supreme Court. So we're going to focus first on the individual mandate, and the court did ultimately uphold the individual mandate, but it took a little while to get there. The first thing that they had to do is determine whether or not they actually were able to hear the case at the time. And this case was started after the Affordable Care Act was originally enacted, and the various parts of the act were phased in over time. The individual mandate was not actually going to be applied until 2014. And so one argument was that the court shouldn't even hear this argument at this time when they received it, because the individual mandate was considered a tax by many, and there's a federal statute, the Anti-Injunction Act, that requires that in order for individual to complain to the court about any tax that is being applied to them, first they have to pay the tax, and then they have to sue to receive a refund. And since the individual mandate had not officially been put into effect, and nobody would have actually had to have paid a penalty yet, the argument was that this case wasn't yet ripe, and the Supreme Court shouldn't even be hearing it at this time. The court instead looked at the individual mandate and the language within the statute, and they stated that in the statute, the individual mandate, if you don't purchase the insurance, it's classified as a penalty under the statute. So the Act, the Anti-Injunction Act, requires that there actually be a tax. And because the individual mandate is classified as a penalty within the language of the statute, the Anti-Injunction Act does not apply. Now keep this in mind, because the court does some maneuvering later, and the Anti-Injunction Act, the fact that this is a penalty and not a tax, this applies only to the application of the Anti-Injunction Act and whether or not the court can actually hear this case, but it does not apply to whether or not it's a tax when you get to the constitutional question. So one argument, the first argument made, was that the individual mandate went beyond the scope of Congress's authority under the Commerce Clause. And as you recall from earlier in this semester, the Commerce Clause allows Congress under the Constitution to regulate commerce and its activity. And the argument was that the individual mandate, by requiring individuals to purchase a product, it went beyond what Congress's authority was under the Commerce Clause. And the court agreed. The court argued that Congress can regulate commerce and all of its activity, but the individual mandate was sort of putting this on its head, and that the mandate actually compelled individuals to become active in commerce. So instead of just regulating the activity, they were requiring that activity be made. And by requiring the activity in commerce to purchase a product, rather than just regulating the already moving commerce that was occurring naturally, this went beyond the scope of Congress's power. And the court said, Congress, you cannot use the Commerce Clause to regulate individuals who are not participating in commerce. This would have unending application, and it's just beyond the scope of your powers. And so under the Commerce Clause, the individual mandate was unconstitutional. So then the court looked at whether or not the Congress had authority under the Necessary and Proper Clause. Congress can act to regulate powers, regulate things that are necessary and proper in order to have authority over another power that they might have. So if they need to pass a law in order to make sure something happens that they have authority to do, then they can use the Necessary and Proper Clause. And for the Necessary and Proper Clause, they have to naturally have had that power granted to them in the Constitution in order to use the Necessary and Proper Clause. And the court looked at this case and they said, with the individual mandate, what you are doing is you're actually using the regulation to give Congress the power to do something. And so this is not a proper expansion of federal power. And so this case, having the individual mandate is not, it's outside of Congress's authority, and it goes beyond the ability to use the Necessary and Proper Clause. So under the Necessary and Proper Clause, the individual mandate is not constitutional. So under the Commerce Clause, the individual mandate was found to be not constitutional. And under the Necessary and Proper Clause, Congress did not have the authority to enact an individual mandate for compelling individuals to purchase health insurance. However, the courts are required to continue to look at all possible ways. So they continued to look, and they looked at an alternate argument that the government made about the constitutionality of the individual mandate. And what they decided was the individual mandate, even though it was classified as a penalty within the text of the statute, it is actually a tax. It's a tax on those who don't have health insurance. So the Affordable Care Act requires, it commands individuals to purchase insurance. Under the Commerce Clause, Congress doesn't have the authority to require this, but Congress does have authority, very broad authority, to lay and collect taxes. And under the Affordable Care Act, the shared responsibility of individuals, the individual mandate, is classified as a penalty, but it does control, but that title doesn't control whether the substance and the application of the penalty is actually what's occurred. So the court looked behind what the penalty was, and they determined that it was not a penalty, but it was actually a tax. And so because it was a tax, and Congress does have the power to lay and collect taxes, the individual mandate could be upheld under Congress's authority to collect taxes. And in looking at it, they examined how the Affordable Care Act had set up their penalties or taxes. And they found that the payment of the tax was not so high as to compel purchasing insurance. So you could still have a choice. You weren't, it wasn't such an outrageous tax that you had no choice but to purchase the insurance. You could choose to either pay the tax or purchase the insurance. They also looked at whether or not this penalty or tax was limited to imposition on individuals who had willful violations. So you've probably heard a lot of people say, I absolutely refuse to buy insurance, I'm just going to pay the penalty. That would probably be considered a willful violation, but under the Affordable Care Act, everybody who does not purchase individual health insurance outside of some of the exceptions that they've made for individuals for certain reasons, is required to pay the tax. And so willful violations, when you impose a penalty for willful violations only, that's considered more of a penalty. In this case, because it applied to everyone regardless of your intent in purchasing insurance, whether you were willfully choosing not to participate in the individual mandate or whether you just didn't get around to purchasing insurance, you had to pay this tax. So because it was not a penalty imposed for willful violations, it was imposed on everyone, it's a tax. Also, they looked at the fact that under the Affordable Care Act, the IRS is charged with collecting this penalty or tax and under its normal means of taxation. So the IRS, when you file your taxes, you would have to pay the tax if you do not have the insurance. And this is done under the normal means of how the IRS collects taxes and how other things are doing. So based on this review of whether or not how this penalty is imposed, the court did determine that it was a tax. Because it was a tax and Congress has authority to lay and collect taxes, the individual mandate was upheld as constitutional, and we move forward with the Affordable Care Act and the individual mandate. The court then turned to whether or not the Medicaid expansion could be upheld as constitutional. And the court found that the Medicaid expansion requiring every state to expand Medicaid did violate the Constitution because the federal government cannot require states to pass any kind of regulations or do anything that it does not want to do. And this Medicaid expansion, it threatened to take away funding from the traditional Medicaid for states that declined to comply with the expansion. The court held that Congress can use the spending clause to establish cooperative state and federal programs, but the state has to voluntarily and knowingly accept the terms of the program. So if the federal government, for instance, wanted a state to lower the speed limit or something, it could say, if you lower the speed limit, we'll give you additional funds. The state then could choose whether or not to do it, but it isn't required to do it. So Congress cannot require the states to regulate. That's a violation of the Constitution. The states are their own entities, and the federal government cannot require them to do something that they choose not to do. And in this case, the threats to terminate funding for the traditional Medicaid was a means of pressuring the states, and this ran counter to the federalism. Under the ACA, Health and Human Services had the authority to penalize states that chose not to participate in the Medicaid expansion. And the penalty was that they could lose over 10% of their overall budget. So they would lose the funding for their federal portion of the funding for the traditional Medicaid if they did not expand. And for many states, this was a huge component of their budget, and the court just felt that by threatening to take away that funding, for some states 10% of the overall state budget, that was too coercive, and so because of that, states wouldn't have any choice, and therefore it was as if Congress was requiring the states to regulate. The government did argue that expansion was just a modification of the current program, so it wasn't like they were requiring states to completely change, but they were just modifying the current Medicaid. But the court didn't buy this argument, and they said that the expansion in extent was an entire shift of the program. The original program provided health care to vulnerable populations, so you had pregnant women and those with frail elderly and people who, a very limited population. With the ACA, Medicaid was expanded to include an entire population of non-elderly individuals who had an income below 133% of poverty, which was a broad expansion of traditional Medicaid and was not just a modification. So in looking at this, the court said, we don't have to throw out the entire statute. The remedy is we're just going to preclude the federal government's ability to withdraw existing Medicaid funds for states that choose not to expand Medicaid, which is kind of where we are in this environment. You still hear about states choosing whether or not they're going to expand Medicaid. This has become a very political issue, and a lot of the states that have chosen not to expand Medicaid typically have Republican governors or Republican legislators. Traditionally, the Republicans tend to not be in favor of the Affordable Care Act, and so typically it's those states in which there is that sort of political desire not to expand Medicaid simply because they don't agree with the Affordable Care Act. So you do have a number of states that have chosen not to expand Medicaid, even though the federal government is paying for a 100% to 90% of the expanded population of Medicaid. So that's where we are after the NFIB versus Sebelius case, and this was decided in 2012. So the Affordable Care Act moved forward. The only change was that the states were not required to expand Medicaid. So we've had a lot of discussion about whether or not states would expand. The next case, King versus Burwell, also deals with federal versus state in just a little bit of a different way. And this case deals with statutory interpretation rather than constitutional interpretation. So in the NFIB case, we looked at whether or not what Congress did was constitutional. So the court looked at constitutional authority and had broad ability to interpret that. In this case, we're looking at just the interpretation of the Affordable Care Act statute itself. And the question before the court dealt with IRS rulemaking, and IRS looked at the Affordable Care Act, and it came up with a rule that individuals who purchased health insurance on an exchange would be given tax credits if they met certain income requirements, and that would enable them to purchase health insurance at a rate that was affordable for them. And the question is whether within the language of the Affordable Care Act, whether the state itself must have established its own exchange. A lot of states relied on the federal government, the healthcare.gov, to operate as its exchange rather than setting up its individual state exchange. So instead of having 50 state exchanges, we have a couple of states that have their individual exchange, but most states did rely on the federal government to put together the website and the backbone for that. Under the Affordable Care Act, there's a phrase that requires the individuals to receive credits. They have to purchase their insurance in exchanges, in quote, established by the state. And so that's some of the argument is whether or not the exchange had to be established by the state, or whether or not using the federal exchange complied with the intent of the Affordable Care Act. And this case was argued before the Supreme Court in March, and the opinion is expected the summer of 2015. And when they did set up the Affordable Care Act, it was anticipated that states would be setting up their own exchanges, but as money became tight, as a lot of things changed with the Medicaid expansion, whether or not states had to do it, it became very political. Again, the federal government, the Affordable Care Act did have language that if the states failed to set up their own exchange, the federal government would step in for those states. And so a lot of states did let the federal government just step in and use their exchange. And so the question is whether the plain language of the statute requires the IRS to only give credits to individuals who purchase from a state exchange, or whether the IRS's interpretation that credits could be given to individuals who purchase insurance on a state or federal exchange. So the issues in King versus Burwell, besides the legal issues, outside of the legal issue, is that this would have a significant impact on a lot of individuals if the court sides with the plaintiffs in this case, the ones who are arguing that they live in a state that did not set up its own state exchange, and that the IRS's interpretation that they would have tax credits requires that they would have to purchase insurance, because then it would be affordable enough for them to purchase it, and they don't want to purchase insurance, so they brought suit. And the problem is that less than half the states set up their own exchanges. So if the ACA does require that the state have its own specific exchange under an interpretation by the court, then there's going to be a significant number of individuals who are not going to be able to continue to afford health insurance. It's estimated there's about 4 million Americans in this situation, and that the tax benefit, the credits, are necessary for a wide swath of these individuals to be able to afford health insurance. And so if they can't afford the health insurance, they won't purchase the health insurance. If the tax credits aren't available, then then the argument you've probably heard of the death spiral, in which the health insurance becomes too expensive for individuals who are healthy but might otherwise purchase the health insurance. So the only people who will be buying the health insurance are those who are sick and in need of health insurance. So the cost of the health insurance is just going to continue to go up until it just becomes too unaffordable for anyone to maintain, and it just creates what they call a death spiral, which is why the individual mandate was enacted, in order to require that individuals who are healthy purchase the health insurance, because they did also, under the Affordable Care Act, eliminate the requirement that insurance companies could deny people for pre-existing conditions. So because they have to take everyone, if we don't have these tax credits, and millions of Americans can no longer afford health insurance, the concern is that it will eventually, the whole system will fall apart, because it will become too expensive for those who do necessarily need it. So the two arguments in the King versus Burwell case, so the advocates in favor of the law argue that you have to look at the statute and the IRS interpretation according to what Congress intended. And they argue that the overall aim of the Affordable Care Act was to provide tax benefits to lower-income Americans to underwrite the cost of insurance. The purpose of the Affordable Care Act was to make sure as many Americans as possible could achieve the ability to afford health insurance, to have health insurance, either through Medicaid expansion or through these tax credits. They argue that if you look at the intent of the entire statute, this specific phrase that the plaintiffs are clinging to is just a small little phrase within the entire context of the law. If you look at the entire law, there should be no difference if the exchanges are being run by the federal government or the states, because the intent of the law was to ensure that individuals could afford health insurance. And those who are arguing against, not in favor of the Affordable Care Act, the plaintiffs in this case, argue that the court shouldn't even get to looking at intent or context, because when they look at the language of the statute, it is plain and unambiguous. If you just look at this one phrase, it specifically states that Congress and the ACA referred only to a state. It did not say state or federal. It didn't look at any of that. You just have to look at that one phrase and determine that for the tax credits to be available, it has to be an exchange established by a state. So for those of you who are interested in learning a little bit more or hearing the arguments, I've posted some links to the Supreme Court oral arguments and the audio there. If you prefer to read it, there's a transcript as well, so you could just read it instead of listening to it. I'm also posting an amicus brief on the King versus Burwell case from a number of organizations that work on health policy. And you can look at, you can read through the brief and you can see some of the arguments they make for the policy reasons. The plaintiffs and defendants, the plaintiffs and then the government as the defendant in this case, have to argue a lot of the legal prior precedent. They have to argue a lot about the authority of IRS to make their interpretations and how the court should look at interpretations of agencies and those types of things. So they kind of focus on that, but an amicus brief is a friend of the court. It helps the court look at some of the issues outside of the legal issues and brings it to their attention. And so I'm posting that amicus brief if you want to read through it. It does talk about who's going to be impacted, how it impacts them, and it really kind of looks at the advocacy from more of a public health type of statement. And so I'm posting that for you to read if you'd like. So this is the end of this. If you have any questions on any of this or are uncertain about any of the litigation or things that you hear, feel free to email me and I'd be happy to chat with you about any of these things. But I've really enjoyed talking with all of you this semester and wish you all the best of luck on your papers. If you have any questions, please don't hesitate to contact me or Dan, and we will work with it. Also, your assignment this week, both the weekly discussion and the other, will be working with some of your peers to help finalize your papers. And so I hope that is helpful for you. I'd love any feedback that you have, and I wish you all the best in your future careers.